the established constitutional order and to do so in their power to restore this constitution after it has been suspended, overthrown, abrogated, or amended.
In other words, to make it simple, when an amendment disturbs the constitutional order, because the other ones are clear. If you overthrow, you abrogate, that's clear. But for the amendment, as long as it disturbs the constitutional order, then you and I are duty bound to rise up.
When does
defend?
Amendment constitute a coup?
There is a qualification to what my Lord Justice Kapuru has cited. It is only if the amendment has been done, the suspension, overthrow, abrogation, or amendment has been done contrary to the provisions of the Constitution.
And that is the case of the petitioners.
And my case, our case, is that the Parliament acted within the provisions of the Constitution.
As you are going to prove.
As we shall prove.
Okay. My only issue was that as long as the amendment is by Parliament or by referendum, there's no...
I said earlier, within the methodology provided for under the Constitution and the respective laws.
So today the microscope is to see whether it was within.
That is exactly what we are going to demonstrate.
Or in contravention of.
Council.
My Lord is...
Sorry, if that is the position, do you then, Council, agree that each and every provision in the Constitution must be strictly applied, interpreted, and complied with so as to ensure the fundamental spirit of the Constitution?
My Lord, that is exactly what I stated, only in different words.
Thank you very much.
Proceed.
My Lord, I have listened to some insincere submissions from my colleagues.
No. You can't say insincere. Leave it to us if there was insincerity. Let's say, and you'd say incorrect. Just use the word incorrect.
Correct.
This was my opinion, but if my Lord...
You can't impute sincerity on your...
In my view, incorrect submissions from my colleagues, Council for the Petitioners.
I think the correct quote is that I beg to differ. Yes. You put your position, they put theirs, and we judge who is sincere, who is incorrect. Put your position. I beg, I oppose this petition, I support the amendment. These are my reasons.
As I said, my lords, I don't have the mandate.
That is founded now. Honorable Attorney General. Honorable Attorney General.
That is
that is based on two things. One, the two sides are still bound by fraternity of both being officers of this court. We are not opponents. The petitioners and the respondent may be opponents, but counsel are not opponents because you are both officers of the court. Two, you belong to a fraternity, and the fact that you represent that side and represent the other side does not drive a wedge between the two of you. You're still in one fraternity after courtesy.
I will adopt your methodology, your wording, and say I have listened to incorrect submissions from my colleagues, Council for the Petitioners. Trying to argue that when the Parliament enacted the Constitutional Amendment number 1 of 2018, they usurped the power of the people. my submission is that Parliament has the power to do so, provided it acts within the confines of the Constitution and the law. And as I said earlier, Parliament acted strictly within the confines of the Constitution, the law, and its rules of procedure.
Rejected the advice of the Honorable
For good reason, Parliament has the mandate and the power. But Lords, we shall be submitting on those issues specifically. It is our intention to demonstrate that all amendments contained in the Act were made pursuant Article 259, which is explicit on the power of Parliament, and that they are not inconsistent with any law as stated in the various constitutions. My Lord, the power of Parliament to amend the Constitution was demonstrated in the case cited by my learned friend, the Honorable Rukwago, the case of Reverend Christopher Mutikila, which is on record. In that case, my lords, the respondents filed an application challenging the prohibition of independent candidates for presidential, parliamentary, and civic elections introduced by the Constitution Amendment Act. The Act had made it compulsory for such candidates to be members of and be sponsored by political parties. The trial judge held that such candidates could still contest, but he did not declare the Act unconstitutional. There was a further where the judge upheld the decision of the single judge and appeal before 3 judges. The 3 judges too did not strike out the amendment, as in their own words, they could not clothe themselves with legislative powers. My Lord, my interest in that judgment is on page 15, and I want to quote verbatim. The Lordship said, "We are definite that the courts are not the custodian of the will of the people." I'm quoting verbatim. That is the property of
you thought we would take offense on it. Why are you defeated?
No, my lords, it is for emphasis sake.
Okay.
The Lordship said, and I quote, "We are definite that the courts are not custodian of the will of the people. That is the property of elected members of Parliament. So, if there are 2 or more articles or portions of articles which cannot be harmonized, then it is Parliament which will deal with the matter and not the court, unless power is expressly given by the Constitution." End quote. My lords, it is important to note that in that case, the appellant had sought to rely on the doctrine of basic structure. Council Kwago, Mr. Mbale Mabilizi urged strenuously for the application of the basic structure doctrine. On that doctrine, my lord, their lordships in that Mulika case had this to say: and I quote again, we agree with Professor Kabudi that that doctrine is nebulous. Nebulous meaning it is misty, it is cloudy, it is hazy, according to the dictionary. As there is no agreed yardstick of what constitutes basic structures of a constitution. On page 29 of the judgment, their lordships went ahead to examine the constitution of the Republic of Tanzania. And they said, and I quote again, quote, now, let us examine our constitution of 1977. We have already seen that Article 98, which is the equivalent of our Article 209, provides for the alteration of any provision of the Constitution. That is, there is no article which cannot be amended. In short, there are no basic structures. What are provided for are safeguards. My lords, like we have safeguards in Article 260. The Lordship said there are no, what are provided for are safeguards under Article 98, 1A. In the Tanzanian Constitution require support of 2/3 of all members of Parliament, require some local councils of Zambia and Tanganyika as it then was, and all that. And I'm saying those are safeguards akin to what is contained in our Article 260 of the Constitution. And actually, they listed 8 matters which they considered as what would constitute basic structure. Then they concluded, and I quote again, these matters, the matters they listed, could have been basic structure in the sense that Parliament cannot amend them. However, they are amendable, like in our Article 260 and others. The matters which were specifically put not to be amended by Parliament. Their Lordship said they could have constituted basic structures, but then found that following the procedures, even those matters could be amended. They said, however, they are amendable once the procedure for amendment is followed. And the conclusion they had was, and I quote, so there is nothing like basic structure in our Constitution. And I want to adopt their conclusion with approval relating to our Constitution. Their Lordships concluded as follows. It is our, and I quote, it is our considered opinion that the basic structure doctrine does not apply to Tanzania, and we cannot apply those Indian authorities which are in any case persuasive when considering our Constitution.
Why should we then apply Tanzanian case which is not applicable to our history?
No, my Lord, the conclusion was the best principles doctrine.
You refuse to follow Indian principles. Why
Yes.
we follow Tanzanian ones? We have our own history. Yes.
I am going to justify why we should.
Where their constitution abrogated in 1966 and 67, they have a coup of Amin.
My Lord, I look at today.
wherever actually that was what was where the put the preamble. Does the preamble provide the basic structures of the Constitution? Doesn't it provide the spirit and the foundation of the Constitution? That is one. Two, how would you regard provisions of the Constitution like Article 44 of our Constitution, which is to the effect that notwithstanding anything in this Constitution, there shall be no derogation from the enjoyment of the following rights and freedoms. Aren't these basic to the spirit and the foundation of the Constitution?
Put also differently, or in addition, right? In view of the preamble, which I asked you to explain whether it still remains a preamble on our body of the Constitution, can't we say, quite authoritative, that the Tanzanian Constitution, which was being interpreted, construed in the authoritative cited, is fundamentally different from the Ugandan Constitution in the light of what was the preamble but has now been absorbed into the body of the Constitution by Article 88. Can't we say the two constitutions are fundamentally different and different considerations apply in construing them?
I notice, I would point out that the Indian Constitution had what they called the basic structure entrenched in their Constitution. But for us, the basic structure is contained in a number of articles of the Constitution, which it is our submission have not been affected by the amendment at all. Which I agree with my Lord Justice Kasule, Article 44, the Bill of the entire Bill of Rights has not been affected by the Constitutional Amendment Act. There are so many areas which have not been affected at all when Constitutional Amendment Act number 1 was promulgated. That's the best, what would constitute the best structure of our Constitution has not in any way been negatively affected.
That is not how I understood you. I understood you to submit that there is no basic structure. Every article can be amended. It just depends on the procedure, and everything is fair game. But now you appear to be saying, no, apparently. I think you have changed your position.
Actually, you've not only changed the goalpost, the entire football field.
My Lord, my solution was very clear. Once you give power to the people, and the people have decided on what can be amended and what cannot be amended, and how every matter can be amended, and explicitly included it in the Constitution. Then, like in the Tanzanian situation, the basic structure now depends on what the people expressly put in the Constitution. I want to stop that. So, my lords.
No, I thought you said something which is important. I don't know if I got you right. Are you saying, in effect, general principles do not override specific provisions in a statute? That's what you're saying.
My lord?
That general principles of law or doctrines do not override specific provisions in the document where one wants to apply a general principle.
That is exactly my submission, my Lord. The principle of basic structure was applied by the Indian Supreme Court. By the way, even in the Indian Constitution, which applied it for the first time, there was nothing. They too brought it from a scholarly article from some German scholar.
Like the one Mr. Mbale relied on, the PD cases.
Yeah, just a scholarly article. They brought it from there, applied it, but the Tanzanian court is saying that that is just a principle which does not tie them in light of express provisions in their constitution. And that position, and I call upon my lordships to agree with me.
Uganda, that's what my lordship is saying. I thought your argument was that look, that's not part of the basic structure. That's what I was following. But when you're not alone, you went on to say there's no basic structure.
But that was my submission. I said whatever was amended, it did not in any way touch or abrogate the basic, what would be termed as the basic structure of our constitution. That was my submission. My Lord,
Okay, proceed.
my Lord,
Proceed.
that was by way of background, or the submissions on the usurpation of the people's powers, usurpation of the people's powers while enacting Constitutional Amendment Act number 1 of 2018 are irrelevant. I stated earlier, my lords, that once elected representatives of the people carry out their duty of the Constitution by acting with the I want to stop with that.
Just a moment, you have some...
The Attorney General given a background, and you have brought in Tanzania within East Africa realm. And it is with the people of Uganda recalling our history, which has been characterized by political and constitutional instability. Is that the position with Tanzania?
Apparently, my lords, the Tanzanian judges were also referring to the Kenyan authorities, and my submission is that they too have a similar preamble in their constitution, and everything that was done, that was put in our constitution is within the spirit
provided that constitution as at that time, that's one in your bundles of authorities. My Lord, for our consideration, were you kind enough to provide the Tanzanian constitution, that would be bundles of authorities.
And the Kenyan one.
with the leave of God, Lord,
Authorities, you cannot say that.
Allow me just to make this remark. In the Mbale case, appealed 1 of 2002, Justice Kampala said the above amendments, Section 5 Act of 13 of 2000, which amended Article 97 of the Constitution, can only survive in a jurisdiction where Parliament, like United Kingdom, is supreme. In Uganda today, the amendment amounts to a coup d'etat against the sovereignty of the people and the supremacy of the Constitution. It cannot exist side by side with Article 1 and 2 of the Constitution. In other words, the structure, it doesn't talk about the theory, but it is there. It's there. And this is the judgment of the Supreme Court. Actually, an amendment can amount to a coup.
My Lord, that's the opinion of the justice.
What do? We are bound by the Constitution. We are bound by the decisions of the Supreme Court.
I just persuade you, my Lord, to depart from the position.
No, we can't. The decision of the Supreme Court shall bind every other court in Uganda.
Learned Attorney General, you know very well that however much we disagree with the Supreme Court, remains the authority. Tongue in cheek, we have to accept.
As I stated, I don't have the mandate to argue with the adulteries. My role is to persuade you. Besides, I am not sure whether that was the unanimous stand of the Supreme Court.
Fine.
However, my lords, my role now is to persuade the adulteries in the direction in which I submitted. And I shall be doing exactly that. My lords, having finished with that historical background, I will call upon the learned Solicitor General, number 1, 2, 3, and 4 as framed.
May it please you, my lords, my name is Okay. City, the Land Attorney General, with my colleagues. My lord, we shall handle issues 1 and 3 together, then followed by issues 2 and 4. This is because the complaints underlying the joint issues are likely the same. And my lords, issues 1 and 3 were framed parties as follows. For emphasis, I want to paraphrase whether sections 2 and 8 of the Constitutional Amendment Act 2018 extending or enlarging the term and life of Parliament from 5 to 7 years is inconsistent with and or in contravention of Articles 1, 8A, 61, 2 and 3, 77, 3, 77, 4, 79, 1, 96, 105, 2B, 261, and 2. And issue number 3 was whether Section 6 and Section 10 of the Constitutional Amendment Act number 2018 extending or enlarging the term of local government council from 5 to 7 years is inconsistent with and or in contravention of Articles 1, 2A, 1763, 1814, and 259, 2A of the Constitution. Section 2 of the Act amended Article 3 of the Constitution by substituting the word 5 appearing immediately before the word years with the word 7. Section 8 amended Article 289 that provides for a with the word 7. Section 10 of the Act amended Article 291 by making the term of the current local government council to 7 years applicable from the current term of the local council. My lords, it is the contention of the petitioners joined to that this section extending or enlarging the term of life and life of Parliament and the local councils from 5 to 7 years are inconsistent with and or in contravention of Article 1, 88, 62, 73, 79, 1, 96, 1051, and 233, 261, and 289 of the Constitution. Before delving into the resolution of the issues, we wish to point out briefly the principles of constitutional interpretation as expansively and exhaustively handed down by this court and the Supreme Court in Uganda in several cases. In this regard, we refer to the case of Kawanga, Mbale, and another versus Attorney General that was mentioned by its Lord. Pages 14 and 16 of Justice Kanyahamba's judgment. Yes, then was. I refer you, my lord, to tab K of volume 3 of the respondents list of authorities. Tab K. And then
authority number 1.
Authority number 2. Tab K. Volume 3 of the list of authorities. Then I will pages 14 and 16.
Just K.
Yeah, tab K.
Tab K 14, I see that's the sort of is.
Okay.
Tab K.
Page 14, my lord. The judgment of justice. 14.
Page 14.
Start from page 14.
Paragraph on page 14.
Paragraphs are not numbered.
No, paragraph is still from the line, not number 9, paragraph. The first paragraph begins with failure, the second paragraph is paragraph 1, then the last paragraph is this ground was.
And was referring to the case of Kinyifunza and Attorney General.
Page 14? Page 14 or page 14? Which? The handwritten 14?
The handwritten 14.
Where he says the entire constitution has to be read.
Page 14.
At the bottom,
Yes, we have seen.
you have seen.
But is this the judgment of Justice Kanyuha?
Yes.
We seem to be having different documents.
Just this is the your
Honorable Solicitor General, are we on volume 3 of your list of your authority?
Yes, my lord. Yes, volume 3.
And then
Tab K.
tab K
Yes.
is the authority, the judgment of the Docket 6J. Is that right?
With that,
Then when you go to page 14,
Handwritten.
handwritten.
Yeah,
No, no, mine is not handwritten.
where there's a yellow sticker,
There are 2 page 14 which are handwritten. I think you're talking of the second 14.
it's not handwritten.
It's not handwritten.
And you see, the judgment of Justice Kanihamba follows that of Justice Odell. But that would not have been the order,
My lord, apologize.
because judgment of Justice Kanihamba, he was the junior here in this panel.
Did they write the lead judgment? Oh, what are you saying?
The judgment should have been Odoki, Odell, Sekoko, Karokora, Mlenga, Kanihamba, final judgment.
Yes, I'm referring specifically to one of.
I just say
My
that
lord, some information.
in order.
Yes.
Just Kanyihamba was the lead. He wrote the lead judgment
In this
Yeah.
matter.
in that matter of Semogen. So it was the first judgment.
No.
Even if once the CJ
But Solicitor General, what do you want to say about this matter?
What I want to say, there are a number of other cases compounding this principle of constitutionalism. That's what I wanted to, constitutional principle, that's what I wanted to say.
Okay, we are
and I
there.
wanted to refer.
We are there. Entire constitution has been read.
Yes.
In the case of Tinyafuza,
Yeah.
We are there.
we are there.
Then I also want to refer you to the case of Tinyafunza and the one of Saleh Kamba. That is on.
Why don't you first finish why you brought us to page 14?
Yes. It says, my lord, that the entire constitution has to be read as an integral whole, and no one particular provision destroying the other, but it sustaining the other. This is the rule of harmony, rule of completeness and exhaustiveness, and the rule of paramountcy of the written constitution.
Yes. Very well then. We have it here. Don't
Yes.
read the entire thing. What the principle is that the Constitution should be interpreted in this as stated.
Yes, yes, my lord. So I think these principles.
No, you see, but the other you have referred to us to the judgment of Justice Kanihamba. Instead, Justice Manyeli in your Fuza. Yes. Because Justice Kanihamba was just quoting from
Yes,
Justice
my lord.
Manyeli.
Yes, my
Further
lord.
on, he goes on to discuss what he has quoted. So
Yes, my lord. That's what I'm
first of
saying.
all, that would not have been the decision of Kanihamba. It was the decision of Justice Manyeli.
Yes, but it was referring with approval.
If you no, it was not. You got page 15. The provision shows quite clearly that the provisions of the Constitution or any other law do not have this specifically mentioned to be amended by implication or inclusion. That is, those are the ones Justice Kanihamba.
Yes. My lord, we are just talking about the principle of constitutionalism. We are not talking about that. We are referring on a specific aspect only. On the principle of constitutionalism, my lord. Issues of infection will be discussed later, my lord. Hello. As follows. One, that in determining the constitutionality of legislation, in effect, must be taken into consideration both purpose and effect are relevant in determining constitutionality of either an unconstitutional purpose or an unconstitutional effect animated by the object of the legislation. Animated by the object the legislation intends to achieve. Secondly, my lords, the entire constitution has to be read. No particular provision destroying the other, but each sustaining the other. Three, my lords, the history of the country and the legislative history is also relevant and a useful guide in that we rely on is that the national objectives, directives, principles of state policy are also a guide in the interpretation of the Constitution. My lords, we shall apply some of the above principles of constitutional interpretation in the course of our submission. My lords, Parliament derives its power to make law for Uganda from Article 79 of the Constitution, and it exercises those powers by virtue of Article 91 of the Constitution. And if I may quote, it provides subject to the provisions of the Constitution, Parliament shall have power to make laws on any matter for the peace, order, development, and good governance of Uganda. Clause 2 provides that except as provided in this Constitution, no person or body other than Parliament shall have power to make provision having the force of law in Uganda except under authority conferred by an act of Parliament. And in Article 21(1), it provides that subject to the provisions of this Constitution, the power of Parliament to make laws shall be exercised through bills passed by Parliament and assented to by the President. So, my Lord, you can see that Parliament has the powers to make laws, and we want to argue in our submission that it is these powers that Parliament exercised when it was passing these acts. And we shall mention the specific provisions of the Constitution.
My problem, learned Solicitor General, is that you haven't begun submitting on those issues 1, 2, 3, 4, which you are repeating what the Attorney General took 1 hour to seek to persuade us as the basic principle which would guide your submissions. Parliament had acted within its powers provided for in the Constitution. The learned Attorney General dwelt on that for minutes. If you're going to repeat this, we are going to run into problems. We were very firm with counsel for the petitioners on. If a matter has been dealt with, even if you are prepared to submit, skip it and come to the matters which were not dealt with. That is why we use the principle of incremental usage of time. Not that again you begin from square one, where somebody has really climbed the ladder, has left the ladder, is now on the 3 branches. You still want to climb the ladder to reach there. No.
My Lord, this was an introduction to and a background, the foundation of my submission. I wanted to bring it to the attention of this so that their lordships can know where we are coming from.
Proceed with the submission of the issues now.
My Lords, I was saying these are very important, extensive, and exclusive constitutional powers and functions of Parliament. Now, my Lords, the Acts of Parliament Act defines a bill in Section 1C as a draft. Parliament's Acts of Parliament Act
Yes, proceed.
Yes, my Lord. I was saying a bill is provided, the definition of a bill is provided for in Section 1 of the Acts of Parliament Act. And it says a draft of an act of Parliament which includes both a private member's bill and a government bill. So it includes both the private member's bill and a government bill. And Chapter 18 of the Constitution, my lords, prescribes the legislative procedure for amending the Constitution under Articles 259, 260, 261, and 263. This is what Land Attorney General was referring to. That we want to show, this is our case, that Parliament has the powers to amend the Constitution under specific provisions. And this is what I'm submitting on, that in Article 259(1), it provides that subject to the provisions of this Constitution, Parliament may amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid out in this chapter. Then it goes on to 2. This Constitution shall not be amended except by an act of Parliament. A sole purpose of which is to amend this Constitution. B. Act has been passed in accordance with this chapter. In Article 262, it provides as follows: a bill for an act of Parliament to amend any provision of this Constitution, other than those referred to in Articles 260 and 261 of this Constitution, shall not be taken as passed unless it is supported at the second and third readings by the votes of not less than 2/3 of all members of Parliament. My lords, we submit that Parliament complied with the provisions of Chapter 18 in as far as these amendments were concerned, brought under Articles 259 and 262. The petitioners have contended that in passing sections 2, 6, 8, and 10 of the Act, Parliament was acting beyond the powers as granted to them under the 1995 Constitution, since they were acting in breach of articles, all those articles. Maybe with your permission, my lord, I don't need to repeat them every time. It is also the petitioner's case, my lord, that Parliament is amending Article 73 breach Article 94(1), which empowers Parliament to make their own rules to regulate their own procedure under Rules 1041, 1052, 1212, and 1234. Hello? I beg to disagree with this position. And while the petitioner cited the above provisions under the old laws, old rules of 2012, because Parliament has, at that time when this matter was brought, Parliament, they had rules of procedure of 2012. And these were the rules that were cited by the petitioners. The respondent seeks to clarify, we seek to clarify, my lords, that the applicable rules at the time of the second reading, which was on the 18th of December 2017, at page 4 of the answer, attached to the affidavit of Jane Birige, the Clerk of Parliament, as Annexa G of the Uganda Law Society petition, where rules that were that had effect from November 2017, commenced on the 10th of November 2017. And my lords, there in our affidavit of Jane L. Birige, that is on the court record, it is Annexure G, Annexure G, tab 9 of our pleadings, and it is also illustrated in paragraph 45 of the affidavit of Jane Ikulu. Sorry, my lord, I've worked with her for a long time, so. Jane Kibirige in the Ugandan Law Society. Actually, beg your pardon, my lords, was a slip of the tongue.
We can understand.
Yes. So I was referring to that.
But you arrested it in good time.
Yes, I realized.
Yes.
It is paragraph 45, my lords, of affidavit in tab 9. On page 4, sorry, my lord, that was paragraph 45 of the affidavit of Jane Kibirige, that she told the affidavit, and it states that I know that on the 18th of December 2017, the August House convened after the wide consultation with stakeholders, and the Constitutional Amendment Bill number 2 of 2017 was read in Parliament for the second time. A copy of the answers of the Parliament debate. Copy of the answer of Parliament dated 18th, 19th, and 20th December are here to attach and mark G, H, and I respectively. All those tab. H is on tab 10. I is on tab 11. Attached to us. And my lord, the question is then, did Parliament contravene its own internal rules of procedure as it was raised by the Council for the Petitioners? And we are stating that Rule 104.1 of the old rules that are referred to as the 2012 rule became 114.1. Rule 1052 of the old rules became Rule 1152 of the new rules, and Rule 1212 of the old rules became Rule 1312, and Rule 1234 became Rule 1334 of the new rules. Refer you to Volume 1 on tab B and C of the respondents' list of authorities. My lord, the petitioner's contention is that Parliament contravened the principle of the rule of law in not following the rules of procedure. We disagree, we beg to disagree with this, my lord. We have already set out about the legislative function of Parliament, and under Rule 104 of the, I beg your pardon, it is our submission that a bill shall bear, in Rule 1141, that a bill shall bear the aid of a short title and a long title describing the leading provisions of the bill. This is also provided for, my lords, in Section 3 of the Acts of Parliament Act, and it is Part 2, and it provides as follows, my lord.
And the Solicitor General, Rule 1141 you are referring to, is it on the old, because you are now mentioned of the old rules, new rules?
The new rules, my lord.
Then you better become clear.
Much obliged, my lord.
The new rules started, were effective from when?
From the 10th November 2017, my lord.
When was the act? Act was what?
The act
On Facebook.
It was also on 18th December. That's when the bill was brought for second reading. My lord, I was referring you.
So the introduction of the bill, when it was laid before Parliament, was under the old rules.
Yes.
Now, when it went to the committee the Parliamentary Committee?
It was the new rules. The second reading was the new rules that was applicable.
I thought when it came back from the committee, how about when it went to Parliament, not the committee of the whole house,
Yes.
legal and parliamentary, I think, for public participation? Was it under the old rules? Was it still under the old rules or the new rules?
It was under the old rules when it went there.
But it is also your case that certain key core provisions in the old rules were transplanted, that now they are contained under
The new rules.
but textually they are the same.
Textually, they're the same. My Lord, I was referring you to.
If I remember correctly, they also said that the procedure for the amendment was also flawed. For amending the rules. I
No.
remember as it may.
My Lord, I didn't hear that. Procedure of amending the rules. It is not the list, it is not in the pleadings. I didn't hear it.
My Lord, the contention of the petitioners was that the procedure for suspension of the rules during debate
To bridge the gap of 14 days and
Yes,
so on.
my Lord.
So forth.
But the rules were suspended.
I think one or two rules.
Once they become two, then they are rules, not a rule.
Yes, my Lord. Our case is that under Section 3 of the Acts of Parliament Act, the long title describes only the leading provisions in the bill or in the act. And that's why we couldn't have all the issues that were later approved in the provisions in the long title.
No, but does the long title say and others?
And related, I will come to that, my Lord.
Does it say
And related matters.
Because the argument on the other side, this is key. The argument on the other side is that when the bill was introduced, it was specific, it was clear. Everybody who dealt with the bill knew what the bill, from the long title and even the body, the head and the trunk, you could know it was clear. Then along the way, you come to Parliament and somebody tells you no. The menu includes also this, which was not on the menu. When you choose fish or vegetable, the other thing was not there.
And I think that, Solicitor General, the issue of long title is not a simple issue, because I think this jurisprudence, the effect, for example, where a law says we are providing law for access to information and protection of rights, and the law just says the person shall not. It is held to be unconstitutional because that is not the law in the first place, which the long title is talking about. It's talking about expanding rights, and the border is restricting the rights. So
Prohibitive.
so the issue of long title is
My Lord, we shall show that these issues were debated in Parliament and the rules allowed.
I'm just alerting you to the fact that there's jurisprudence around the long title.
Thank you for that information, my Lord. But we are submitting, my Lord, that the long title, I don't need to read it verbatim because it has already been mentioned, but it is basically to provide for eligibility requirements for a person to be elected president or district councillor and blah, blah, blah. But the reading of that bill, my Lord, reveals that the subject matter of the bill, among other things, provided for when elections were to be held for the president, parliament, and local government councils. We submit that Article 61 of the Constitution, which was one of the provisions the bill intended to regulate, related to when the elections on different stages of leadership should be held. My Lord, it is also our contention that the provisions of Article 62, which provides that the Electoral Commission shall hold presidential, general, parliamentary and local government council elections within the first 30 days of the last 90 days before the expiration of the term of the president, and Article 63(1), which says that except where it is impracticable to do so, Electoral Commission shall hold presidential, general, parliamentary elections and local government elections on the same day. The respondent, my Lord, contains that changing the time of the elections of members of parliament and local government council is a related matter to Article 61, which was proposed for amendment by Clause 1 of the bill. There was nothing foreign in that regard. There were debates, my Lord, and the debates are attached. The answers of Parliament of the 20th December 2017 are attached to the affidavit of Jane Kigundu. My Lord, I beg your pardon.
Jane Kigundu is the judge.
I might oblige my Lord.
Council Solicitor General, you have to win Jane Kigundu out of your mind in this case.
Advise, my Lord.
If need be, flush her out of your mind.
I've taken that advice, my Lord.
Yeah, please proceed.
My Lord, I was referring to the attachment. The clerk to Parliament have been advised not to use the clerk. It's easier. So that my Lord, it is...
the other way is for the clerk to Parliament to swear a deed poll and change her name to Kiko, to make your work easy.
My Lord, she would need the permission from her Lordship. Because it can be another issue which will be brought before you here. My Lord, attachment marked I, annexure I, on page 5247 of the answer of 20th December 2017, referring to the issue for discussion. All these issues were brought for debate by Honorable Kusime. It's on page 5247 of the answer. And he submits, and there was a debate, he submits up to page 5248. Then there was debate, and the debate is concluded on page 5254, where the chairperson now clear that, honorable members, I put the question that the new clause be used as proposed. So all these were debated, and the record in the answer is very clear that all these matters were debated. And my lords, Rule 1334 of the Rules of Procedure, the new rules, provides for discussion and debate on that matter. And for debate, my lord, and I refer to the rules. My lords, the rules provide as follows. Clause 4, the committee of the whole house shall consider proposed amendments.
Rule what?
Rule 133 and clause 4. It provides that the committee of the whole house shall consider proposed amendments by the committee to which the bill was referred, and may consider proposed amendments on notice, where the amendments were presented but rejected by the relevant committee, or where, for reasonable cause, the amendments were not presented before the relevant committee. So it is our submission that all these amendments were brought, these issues were brought to the committee of the whole House, and they were debated, and that's how they were introduced, and that's how they became an act of Parliament that is now under contention, my Lord. The import of this is that, my Lord, even those which were not brought before the relevant committee at this stage could be discussed, and that's what transpired from the record, from the answer.
Why wouldn't, if that were the position, or if that is, then why don't you cure the fact that they did not go before the committee for public participation? Why don't you cure that by keeping the 14-day rule? So that there is that semblance of participation, at least the members of Parliament can go back to their constituencies and say, you know what, since the last time we came here, new matters have come up. We think for the stability, for the economic growth of this country, we need 2 more years on top of what you gave us. And they hear what the population will say. The one on whom the power,
my Lord,
vested.
My Lord, I was referring to the rules of procedure of Parliament.
I know.
Allows for certain eventualities. And I think
does the rule take away constitutional provisions?
No, it doesn't take. It doesn't override the constitutional provisions. But we shall submit later on that there were actually consultations, and that actually there was a bonus to democracy in the tune of 29 million that was available.
Come again?
We shall submit that actually the consultations took place, and actually the members of Parliament were facilitated through the Parliamentary Commission.
For the new addition to the bill?
No, for consultations generally.
There is a debate as well that the 9 million was a bribe or consultation. Because some people were
looking for to sit in. A political party uniform, wherever he goes.
My Lord, those were
that's what he says.
My Lord, as to why we didn't maintain the 14 days notice.
No, you're putting it differently. I can't help you. What I was saying, the complaint from the petitions used the 14 days for the necessary consultation, or even send the matter back to the Legal and Parliamentary Committee to deal with that aspect which was introduced. That's what I was asking him.
Yes, my Lord, yes. And now I want to clarify that the 14 days notice is not applicable to a situation.
No, not notice. 14 days is the gap between second and third.
The 14 days sitting,
yes,
is not applicable to a situation when we are amending Article 159. The requirement under the Constitution is that the 14 days are required when we are amending the entrenched articles. The rule would do.
No, well, I'm sure it is in the answer.
It is in the answer.
In the proceedings of Parliament.
Yes, my Lord. Which says at least 3 days after it has been laid on the table by the chairperson or deputy chairperson or a member nominated by the committee or by the speaker. That's the rule we suspended. not we. That is the rule the Honorable Speaker suspended on our application. Proceed.
My Lords, the petitioner contends that Article 77.4 was amended by infection in extending the terms of Parliament and local government, since the purpose was to ensure that Parliament does not exceed its mandate. Reference was made to the minutes of the Constituent Assembly. Intention was for the parliamentarians. It was submitted that intention was for the parliamentarians to face elections and therefore are breaching the accountability principle in not going back for election. It is their contention that Article 1.4 was in effect breached as a result of this action by the parliamentarians extending their term. We respectfully don't agree with this. For us, we contend that Article 77.4 has not been amended in any way by the provisions that were amended by Parliament under Section 2 and Section 6 of the Constitutional Amendment Act 2018. The amendments, my Lord, were strictly in accordance with 259, Article 259 and 262 and Article 94 of the Constitution, which provides the procedures and rules of Parliament. The conditions that exist for extending the terms of Parliament in Article 77.4 are still firmly in existence and were not affected by the amendment of the provision of Article 77.3 as alleged by the petition.
Why not? The issue is you have extended the term of Parliament and there's no more.
That is one of the conditions, provisions, my Lord.
Solicitor General,
You have
the
added.
principle is amendment by infection, which the Supreme Court has said this is possible, and that is their argument. You should address that.
My Lord, that's true. You said that is their argument. It is not ours.
No, it's
For us,
not
we are
the-
saying
It is not their argument. This matter has been litigated upon earlier. In 2000, over the referendum, they first came and said the referendum, there was no quorum. Went back. Passed a law in one day, same day, all the rules were suspended. The same people came back to court. The matter went to the Constitutional Court. There was a split decision. Went to the Supreme Court. And these issues were litigated. This judgment of Mbale being referred to above, all the arguments you are putting forward have been put forward before. And this court said, the Supreme Court said, yes, you can amend by implication. So why do we have to adjudicate on the, why do you have to repeat the same arguments for us to adjudicate on the same things? And what is the purpose of
President?
Precedence? What's the purpose of precedence? And here we have now another article of this Constitution, in my 77, maybe 77.5. The Parliament may extend its term. It is now 77.5. Yes. Yes, it is. 77.5. Parliament can extend its term when it wants. It's what has now been, although it's not written. And that's the argument that actually you have now put it in. But since you have put it in on another page, it is not on this page. No, that's what the judgment of Kanini.
My Lord, I want to clarify on what Parliament did. There is Article 77, Clause 3, which says, subject to this Constitution, the term of Parliament shall be 5 years from the date of its first sitting after the general election. Now, Parliament, in its wisdom, after consultations, found that it was necessary to lengthen the life of Parliament from 7 years. This sub-clause, my lords, is a clause like any other. It could be amended. Now, subsequent to the consultations, Parliament in its wisdom sought to amend this clause, and indeed went ahead to amend clause 3 of Article 77. However, clause 4, did I say 3? No, it went ahead to amend clause 3. However, clause 4 still remains intact and is not in any way affected even after the amendment of clause 77.3, because clause 4 refers to enlargement of the term of a particular parliament. Like if we are saying the term of the 10th parliament should be extended because there is a state of war or an emergency. However, what transpired is that having amended clause 3, the issue was when does this amendment take effect? And that is why we went to transitional provisions. If you look at the Act, my lords, that's why we deliberately put that amendment in transitional provisions. After amending Article 77.3, the question was, when should the amendment start? And members of Parliament, after consultations, felt that it should start with the current Parliament. And even when you have that amended article and clause, the provisions of clause 4 are not in any way affected. They remain exactly as they are. They remain as they are, implying that if during those 7 years, if there is a state of emergency or a state of war, you can extend for 6 months. And it does not in any way infect or affect. The way I understand infect is if by the new amendment you are required to revisit the wording of the word that is being infected. But in my submission, there is no reason for anybody, even after the amendment, to change the wording of clause 4 of Article 77. Therefore, that clause is not infected.
Honorable Attorney General, would I be wrong to interpret Article 77 to the effect that if you take 77.3 and 4 together, that the only circumstances under which the life of Parliament can be extended is when there is a state of war or a state of emergency. Otherwise, the life of Parliament cannot be extended.
Therefore, doesn't amending Article 73, clause 77 clause 3, violate the provisions in 77 clause 4? In other words, it infects. Once it violates, then automatically it infects.
My lords, it is my
Honorable Attorney General, again before you. Was it the vision of the Constituent Assembly that Parliament is vested with powers where, for example, if there is about 6 months remaining for the period of 5 years that Parliament has been in existence, that Parliament can, through an act resolve itself and say, within these remaining 6 months, we are now extending our period for another 5 years. Would Article 77, Clause 3, allow that?
Maybe before you answer, let me also that we have created a situation where Parliament has another way, through other means, given itself power to extend its life. You are not extending the term, you are extending the life, because Parliament has a life. It is born, dies, a new Parliament comes. Now you have extended its life. And the only provision that allows that is clause 4. Now you have put another clause, which is clause 5, saying Parliament can always do that. And that is the issue that the respondents, the petitioners were saying. First of all, you can't do that. You cannot. Parliament cannot. In any event, Parliament was elected for 5 years. 5 years.
The social contract, the covenant.
Yes, Parliament was elected for 5 years. So how can Parliament elect itself
for an additional 2 years?
For another 5 years. For us now, we have elected ourselves for another 2 years.
My lords,
if you can respond,
I beg that we move together.
No, it's okay.
I
want, landed attorney, I want you to respond to this.
Yes, madam.
Then we break for health break. We have health break.
Yes, my lords. My lords, Chapter 18 provides for areas and articles and circumstances under which the provisions of this constitution can be amended. And it says, subject to the provision of this constitution, Parliament by amend by way of addition or repeal, any provision, any, I want to emphasize the word any provision of this constitution. And
you have to do very well. It says subject to this constitution.
Yes, subject to the procedure laid in the constitution. And in my submission, Article 3, Clause 3 of Article 77 is a provision of the constitution which is subject to amendment. And what Parliament did was to look at this article of the term of Parliament being 5 years and say, for reasons we have gathered from the public and we know, the term of Parliament should not be 5 years, it should be 7 years.
So, beginning yesterday.
But wait, I'm coming, my lord.
Okay.
So Parliament, in its wisdom, looked at this article and decided to amend it, to amend the life of Parliament, because it is amendable. If it was not, it would be provided for under Article 259 or 260, but it is not. It would have been entrenched, or there have been a provision somewhere say that you can do anything else, but don't touch Article 77, Clause 3. It's not there. It is a provision like any other. It is my submission that any provision of this Constitution, which is not protected under Articles 260 and maybe 261, is subject to amendment. And having done that, having amended Article 3, Clause 3 of Article 77. The provisions of Clause 4 of the same article are not in any way infected because, as I said earlier, even during the 7-year term, if a state of emergency arose, if there was a situation of war, then Parliament would pursue Clause 4, extend. And there is nothing wrong with that.
I think it's a question of semantics because there are two things. There is extension and creation. If Parliament had created a new term of 7 years, would have a different argument. Then that would have amended Clause 3, creating a new term. Here, it has not created a new term of 7 years. It has extended an existing term of 5 years.
No, my lords, it depends on how one look at it. Because, my lord, if you say if Parliament had created a term, would the two terms run concurrently, 5 and 7 years?
No, they would have moved 5, substituted with 7, which means this.
Look my lord,
the new term would begin after the expiration of this one. That would have amounted to creation of a new term.
My lord,
what happened is extension of existing term. And there is nothing in the subclause 3 that says that those 5 years can be extended, but they can be changed, but cannot be extended.
My submission is, it all depends on how one wants to perceive it. If, my lord, you want to perceive it as creation of a new term, so be it. But the truth of the matter is that this clause 77.3 is subject to amendment if Parliament
This is my family, and I've always taken care of their skin, from their hands down to their toes. I keep their skin feeling soft, smooth and moisturized 24 hours a day, so that they can feel the love all day long. Enriched with pure glycerin and captivating fragrances, trust Clear to take loving care of your family's skin.
Samba need Coca-Cola and win big. Buy any Coca-Cola product, check under the crown, and what you see is what you win. Cash, Hisense TV sets, multi-choice decoders, and much more.
Taste the feeling.